morning. This is workshop 2 in the session. About a month ago, I got to experiment with these online presentations for the first time, and it went well. Must have. They had me back. So we're gonna look today at the workshop 2, which is actually putting the guardianship petition together. So in our last meeting, we kind of assessed, why you might need a guardianship, how the process kind of works, but today I really want to put pen to paper and show you how to fill out the guardianship application. The guardianship application itself is typically available at gaprobatecourts.gov. However, for several months now, they've been having a lot of trouble with that website. And so if you have any trouble pulling it up there, you can also Google Supreme Court of Georgia standard probate forms. And then it will list all of the standard probate forms, so you can get a copy of a blank guardianship petition there. So no matter how many times you want to fill it out and scratch it up, you will be able to do that, and don't have to worry about a scarcity of forms. They're always going to be available there for you online. As part of this workshop, typically when we do these, we do them live, of course, at Focus, and we have a pro bono agreement that we get all participants to sign, because we are giving out, some substantive information here, and it might feel a lot like legal advice, but it is legal advice only in the context of the next hour or so that I spend with you doing this, and we just have to make it clear that we are not representing you in these events. In the matters of putting the petition before the court. So Jade has those, and she will be emailing you those pro bono forms. So if you would just sign and take a picture, whatever, get that back to Jade, then we can have those for our records. So I would appreciate that very much. So I hope everyone is doing well here today. Jade and I were just discussing how nice it is to kind of be able to multitask while you're taking care of kids or doing dishes or whatever the case might be. So I will not be doing that here today. Don't worry. I'm going to give you my full attention. But let's get started now with the guardianship petition and let you see what it looks like. I'm going to share my screen now here so that you will be able to see. Let's see. This is actually what I want to start with. Okay. So this is the actual guardianship petition. When you pull it up online, this is what you will see. And so the very first blank that will be staring you in the face is the probate court of blank county. That is going to be the probate court, probably where you live as well, but it will be the probate court where the proposed ward, which is going to be your child, assuming we're speaking with parents here today through Focus, then it will be the county where the child lives is who you are going to request to receive guardianship from. So in all likelihood, I think that's probably going to be you too, but just in case your child does live in a different county, it's the county that the child lives in. That's where it's going to be the appropriate place to file this petition. So PW is a term that you are going to see thrown around a good bit here with the guardianship petition as we go forward. So first, over there on the left where it says full name of the PW, PW stands for proposed ward. Once someone is under a guardianship in Georgia, they are known as the ward. I get a lot of confusion sometimes from clients. They say, oh yes, my child's a ward of the state, because that's kind of the term we hear in movies and TV shows, that someone's a ward of the state. Your child actually is going to be a ward of the person who is in charge of overseeing their care, the person who's appointed as guardian. So we've got you potentially who's the guardian, your child is then the ward. But until that determination is made by the court, we have a proposed ward. So that's why PW, because we don't know if this petition is going to be successful or not. Only the court can make that determination and decide that yes, someone needs a guardian and needs to become a ward of someone else. So for the time being, proposed ward is the term we'll be using here, or PW for short is what you're going to see a lot throughout this petition. Over there on the right where it says estate number, you will note I've said leave blank. Court will provide an estate number. Like anything, doctor's office, school, whatever, we always get assigned a number. So that's going to be the estate number that will be assigned to your child's guardianship, and you just leave that blank and the court will fill it in at the time that you file the petition. So interestingly enough, as we scroll down a little bit more, now you're going to see, okay, why is this crossed out, this conservator thing? If you were in the last meeting, or if you have done any reading up on things, you know that guardianship is putting someone in charge of making decisions regarding the health and safety of another person. So that award has a guardian who's in charge of making decisions regarding their health and safety. They could also have a conservator, and a conservator is the person who is in charge of making decisions with regard to their finances. You can have a guardianship, you can have a conservatorship, you can have both. But a lot of times for the families that I often work with, and also I would think for focus families, if we've got a child who is 17 and turning 18, and that's why we're getting this guardianship in place, chances are they don't have assets. They don't have a whole lot in their name. So if they don't, well, yes, they might be suitable to have a conservator. If they had assets, they wouldn't be able to manage them. But guess what? They don't have assets. And if we can keep it that way through the use of things like special needs trusts or ABLE accounts, then if we can keep this proposed ward from ever having assets in their name, then we can avoid conservatorship altogether. Once appointed as guardian, you do have to file annual reports every year. They're not that big a deal. But if you were a conservator, you have to file budgets, and you have to file annual returns, and you have to provide supporting bank account statements to show that everything is lining up. So we like to avoid conservatorship where we can, and a lot of times we can, simply with young people who don't have anything in their name. So if you are in that circumstance and don't need a conservator, then you can just strike out right there, petition for appointment of a guardian, leave that, and then just strike out and or conservator, because we don't need conservator and we don't want to get caught up in all the annual return and reporting requirements if the ward does not have income or assets. And we'll look at that in just a minute. So at the time that you file, you'll see here that I've highlighted there 2 or more petitioners. The petitioner is the person who is putting this action before the court, the person who is saying, yes, I am in charge of this loved one, or have been caring for this loved one, and now they need to have a legal guardian appointed. So that's our petitioner. In order to put a petition before the court for guardianship, we need 2 petitioners. So we need both a person who is filing the actual petition itself. Then we need a second person who is going to be a co-petitioner, and really their function can be very limited. But a lot of times they are very actively involved in this person's life, and so they're a natural choice to be a petitioner. But it doesn't have to be. It literally can be someone who just will sign on the dotted line and agrees with you. Of course, they will swear that yes, I know this proposed ward, and I too believe that they need some help in navigating life. But that can be the end of their involvement. Sometimes they don't even have to be at the hearing. Typically if we have 2 petitioners, we're going to have both those petitioners at the hearing. But let's say, for instance, we've got, a parent who lives here, and then an aunt and uncle is going to be the co-petitioner, and they live out of state. They don't have to be at the hearing. But ideally, I like to have both petitioners there, but they don't have to be. So that just gives you an idea of really, you're just kind of using this person as the second person to get this petition going. So you can determine who your 2 petitioners are. If you don't have anybody that can serve as your second petitioner here, then you can use a doctor's affidavit. And if you have flipped through this petition at all before, everyone sees that doctor's affidavit, which is part of the petition, and thinks, oh shoot, we've got to get a doctor's signature. That is only required if you don't have the 2 petitioners. I typically avoid using that doctor's affidavit. And it's simply because it can be hard to get paperwork out of the doctor's office. And if you do use a doctor, as you can see here, the examination of your child has to take place within 15 days of the time the petition is filed. And sometimes it's just hard to line all that up, to get the report out of the doctor's office, to get over to the courthouse to get it filed. So it can just be more hassle than it's worth. 2 petitioners are just fine. So to the extent you're able, I would say use two individuals and don't worry about the doctor's affidavit. So moving on down here to our red text again, we are going to tell the court now, okay, who is the petitioner? Who is the person that is bringing this before the court? So that's going to be you as the person who's seeking to have a guardian and conservator or conservator appointed. So you put your full name of the person. So that's going to be, you know, Mom Smith, whatever your name is. Then the the relationship to the proposed ward, mother, father, friend, sibling, grandparent, aunt, uncle, next door neighbor, whatever it is. Then you provide your domicile. Domicile is the place where you live, and you go on to provide your mailing address. And if those are one and the same, you can put same, or just fill it in there twice. But certainly if your mailing address is different than where you actually live, then you would provide that information. The court does need to know your actual domicile. So you cannot put like a PO box in both of those spots. They need an actual domicile, because if the court ever needs to serve you with anything, they need to know where they can physically find you, not just your mailbox. So all that information is with regard to the first petitioner. Then we move on down to the second part here, as far as we're going to choose either A or B. So this goes back to our discussion of whether we're doing the doctor's affidavit or whether we're doing a co-petitioner. So if you were doing the doctor's affidavit, then you would fill out section B and provide the information regarding the doctor's name and contact information. But hopefully you're able to find somebody, and we can just go with option A here. So petitioner number 2 would initial over there to the left of the A, and then provide the same information with regard to petition number 2, who they are, what their relationship to the proposed ward is, and then also where they live and where they receive their mail. Includes the first page, so congratulations, moving on down. So now we're getting into information about your child. Again, proposed ward PW. So we provide here at number 1 the full name of the person who is believed to be in need of a guardian. Then you provide the age of that person. The person over whom you are seeking to have guardianship put in place needs to be at least 17 and a half at the time that you file. The guardianship will not take effect until your child is 18, but in order to avoid a lag, you can go ahead and file at 17 and a half and get the ball rolling. You know, typically, historically, it's taken about 3 months to get all this from start to finish, from the time that you file until you're in front of the court, the judge is signing the order, and you have your guardianship letters in hand. That's usually, 8 to 12 weeks, so 3 months typically. As you might imagine, it's a little bit slower at this point, thanks to coronavirus. And so at this point, things have changed. They're doing a lot of things virtually. Hearings are taking place virtually. Evaluations are taking place virtually. So you're still limited by that 17 and a half, but I would say if you have an 18-year-old coming up, it's going to be all the more important if the timing is working out for you to go ahead and file at 17 and a half. A lot of times I would say, well, let's wait till 17 3/4 so that everything kind of lines up more perfectly, but definitely take advantage of that 17 and a half at this point in time. So you fill in the age as of the date of filing. The date of birth is also indicated, just your child's date of birth, also social security number. You have to list the social security number. It needs to be all digits, not just the final 4 like we do on a lot of other things. It has to be all of them. And guardianship records in the state of Georgia are sealed. So when this gets filed, it does not become public record. So you don't need to worry about the fact that your child's social security number is lingering out there in cyberspace. The application or the guardianship petition gets filed, all guardianship records are sealed. The only person or people that would ever have access to it are you, your child as the proposed ward, and any court-appointed attorney for your child. So it is not public record the way that a will becomes when you file a will for probate or another lawsuit. So with your child as well, you're going to list their domicile. Forgive my typo that I'm seeing now. Permanent address. The The domicile is going to be where they permanently live. So again, if your child is living in some sort of supportive environment outside of your home, but your home is still considered their permanent address, you can use that address and could actually file in that county. However, if your child has permanently moved out and is in this other environment, then that's going to be their permanent address. Then presently located is the address where the proposed ward can be found to be served. Part of this guardianship process is once we get all this petition put together and we file it with the court, the proposed ward does get served with a copy of it. Now your child might not care, might not even be aware of what it is they're being handed, but to the extent your child is interested and can understand the contents of the petition, they are going to see it, and that is their legal right. So just be aware that at the time you file the petition, your child will be served. And sometimes that service is done by a sheriff's deputy. So you need to be aware of that as well. There might be a police car pulling up in your driveway, coming to find your child and hand the papers over to your child. And you might say, well, my child has no idea what it is that's being handed to them. It doesn't matter. Not all guardians are doing the right thing, or proposed guardians are doing the right thing. And so for that reason, the sheriff or a private process server has to put these documents into the hands of your child. So that's why they need to know where the child is currently living and can be found. Now, right now, it's not very difficult. A lot of people are found at home, but assuming, fingers crossed, come August, our children are actually back in school or out of the home at a day program, then at that point in time, people always worry, oh gosh, well, what if my child's not home? The process servers and the sheriff's deputies are aware of the fact that kids are in school during the day, that young people are in day programs. And so for the most part, these are going to take place during the evening. Sometimes you might even get a call ahead of time saying, hey, we need to get this served. Let's schedule a time. So you don't need to worry about them showing up at school or something like that to serve your child. So you just provide the address where they can be found and can be served, and then also describe where that is. Is that the family home? Is it a group home, a dormitory, a treatment center, something? So you just put whatever it is there, and then also a telephone number for reaching the proposed ward. And a lot of times, you know, that my clients' children don't have their own phones, or they have a home phone, or so you can just put whatever phone is going to be appropriate and closest to getting in touch with the ward. Likewise, people will say, well, my child is nonverbal. I do put that there. If it's where it asks for the telephone number, I'll put the telephone number and then just put in parentheses, please note, proposed ward is nonverbal. So just to let them know, it's pretty rare that they try and call the proposed ward. Even if they were trying to call and schedule service, they're going to call you because they know that you're the go-between. So pretty rare that they would call the proposed ward. But just in case, the court-appointed attorney who gets appointed to represent your child in all of this, they as well might try and contact your child. So they would want to have that phone number. So that paragraph 1 is really just all about giving the demographics for your child, how old, where to find them. Section 2, sometimes guardianships are filed because there's a crisis going on. Maybe someone's in the hospital, but soon they're going to be discharged from the hospital. Takes a while to get all this through the court. So that's what paragraph 2 is asking about, saying, is there any anticipation that this proposed ward is going to be moved within the next 3 days? So you would just indicate yes or no. I would, as you're filling that out, I would say over the next 2 or 3 weeks is really what you should be thinking on there. So you might say no, not within the next 3 days, but then put a further explanation. I mean, this is all about helping the court find your child, to get your child served so that things can move along. So if there's any sort of information and you're not stuck with this form, you can mark up this form and add additional information as appropriate. So if there's a chance that your child, no, not going to be moved within the next 3 days, but within the next 10 days, yes, well, I would put that there. You just want to help facilitate, keep things moving along. So that's section A. Section B is the proposed ward a citizen of a foreign country? If your child is a citizen of a foreign country, even dual citizenship, anything like that, you need to indicate yes. And then you will go down, as you see a couple lines below, and indicate what country that is. And the reason behind that is your child has rights in the United States, but if your child is a citizen of another country, they have rights there too. And so that country would need to be notified. They do that through consulates to just coordinate and keep everyone abreast of what's going on. So looking back at the second number A under paragraph 2, if your child is anticipated to be moved within the next few days, you would just want to tell them what will be the new location where you would expect to be able to find your child. Okay, so paragraph 3. This is what I call the meat of the petition. This is where you're going to make or break your petition. So first thing there is, A, is guardianship necessary because the proposed ward lacks sufficient capacity to make or communicate significant responsible decisions concerning his or her health or safety? So of course the answer there needs to be yes. That's why we're asking for guardianship in the first place. This language that you see cited at 3A is not a coincidence. That is the exact language that the Georgia Code states has to be satisfied in order for a guardianship to be granted. So, does the proposed ward lack sufficient capacity to make or communicate significant responsible decisions with regard to their health and safety? That's your whole case right there. That's what we are out to prove. Section B, if you did need a conservatorship, then you would say yes, that your child, again, here's that same sort of magic language, lacks sufficient capacity to make or communicate significant responsible decisions concerning the management of his or her property. So again, guardianship has to do with making health and safety decisions. Conservatorship has to do with the management of property. So on guardianship, we're going to say yes. And then hopefully on conservatorship, you're going to be able to say no, only because we want to avoid some of those hassles. So the test for, like I said, your child might not be able to manage things on their own, but guess what, judge? We don't have anything that they need to manage. So again, 17-year-olds turning 18-year-olds, even people that are older than that, typically tend to not have assets in their name. But upon turning age 18, as you know, they might be eligible for SSI, or possibly even earlier if they were eligible for SSI. SSI has its own process through which the Social Security Administration will appoint a representative payee for the ward. So maybe I am entitled to my $783 a month in SSI, but if the Social Security Administration is already directing that to someone else on my behalf, then it's already being watched. And the probate court concedes to that. They say, oh, okay, we recognize that yes, Heather's getting SSI each month, but it's getting paid to a representative payee. That representative payee has an obligation to report to Social Security already regarding what's going on with that money. So we, the court, aren't going to make her report to us too. So in answering B, what I like to do in that circumstance is we say no, and then say the proposed ward owns no property and has no income other than SSI benefits for which his mother, father, brother, sister, whomever has been appointed as representative payee. So, you want to say, yes, we recognize that actually this person does have income, but there's already a process in place for that. And so typically that works just fine in avoiding conservatorships. So that's how you would answer A and B. Now here's the real crux of the petition. If you answer yes to A or B, provide the facts that support the claim of the need for a guardian or conservator. And, it is not enough to say here, my child has Down syndrome, my child has autism, and then move on to number 4. Forget it. It's going to get kicked back to you because not every person who has autism would meet the capacity for needing a guardianship. Likewise, not every person who has Down syndrome would meet the capacity for needing a guardianship. So you've really got to make your case. And this, as you can see, this says continued on next page. But then the note, the court is trying to, prod you along and make you realize this as well. Note, petition cannot be granted unless sufficient facts are presented that support the allegation that the appointment of a guardian or conservator is necessary. While an attached physician, psychologist, or social worker's affidavit is permissible, the petition must specifically provide sufficient facts to support the granting of this petition. So it is not enough even to say, see attached neuropsych evaluation, which might be 37 pages long and cost you a fortune. But you've got to have those facts yourself in the petition, because unless the person who prepared that neuropsych evaluation is going to be prepared to come to the hearing and substantiate what that evaluation says, it's worthless to the court. They need to hear it from you, the petitioner. So they give you what, 1, 2, 3, 4 lines here. Not going to be enough. It could be enough if your child is, nonverbal and not able to understand or communicate any of his or her needs. That might be a circumstance in which you would say, okay, all right, Heather, we can fit this in 4 lines. But typically speaking, even still, I want to give more information than that. So I have provided now here the sample language for the petition. So again, the objective of this paragraph is to prove to the court that your child cannot make or communicate significant responsible decisions. So again, prove, prove, prove. So here are just some examples. And I think this has been forwarded on to you. If not, it's fine for Jade to send this at the time everything is finished. So we go into a lot of detail on these, and I've given you kind of some different examples, but let's just take a look at the first one to give you an idea of truly what it is that we're trying to flesh out here. The proposed ward, Jeff, suffers from mild, moderate developmental delay and CP. Okay, that again, and so some people might say, okay, boom, done. No, we need more specifics. Like how does his limitations impact Jeff? What concerns arise out of the effect of those disabilities? So at the age of 22, Jeff graduated from high school with a special education diploma. He now participates in a pre-vocational day program 5 days a week. He's conversant but has trouble staying on topic. Though able to communicate regarding his medical care, he's not able to weigh and appreciate the consequences when presented with options regarding his medical care. Though he can be left alone for short periods of time, he's unable to be left alone overnight and is not able to live alone. So as you can see, what we're getting at here, we've addressed the healthcare side of things. Yes, he can participate in the conversation, but he's not really going to get it and appropriately weigh and evaluate. And then on the safety side of things, he can't live alone. He's not able to be left alone overnight. And then further speaking to some safety issues, suffers from anger issues for which he's under the care of a psychiatrist. He's been diagnosed as having emotional control, roughly equivalent to that of a 3-year-old. I like to use that. If you have any grade equivalents on anything, my child reads on a 2nd grade level. Like we're saying here, he has the impulse control of approximately a 3-year-old. Anything like that can just, because remember, judges and court-appointed attorneys, who are the other people that are going to be involved in this process that we're trying to convince this is necessary, they don't have a medical background. So you could rattle off a bunch of acronyms and a bunch of diagnoses, which, to you are very clear as to what it means. But that's why when we're dealing with kind of lay people in this medical capacity, anytime you can tie it to an age or a grade equivalent, I think that works well. An IQ score isn't determinative. Someone might have a very high IQ, but, be completely lacking in common sense and health and safety awareness and might still need a guardianship. So I would never say just put, has an IQ of 40 on there and think you're done as well. But it does speak, it is demonstrative, and it's something that, a layperson can kind of understand and conceptualize. So he receives medication for the treatment of his anger issues. He's also under the care of his primary care physician for treatment associated with, oh boy, remember what I was saying about big medical words? I'm not even going to try. With a shunt, and that he has had for approximately 10 years to regulate his cerebrospinal fluid on his brain. Due to CP, Jeff's unable to ambulate and uses a wheelchair. So other things that you might indicate here are, if your child is on medication, are they able to manage that medication on their own? That can be another big thing. Or, would they know if a prescription was filled properly? Would they know to go get the prescription refilled or to make a doctor's appointment? The necessity of making a doctor's appointment. So can they express when they are in pain and what's in pain. These are all just kind of things. And as you read through these various scenarios here, because again, we've got several of them that are provided. When you read through those various things, anything that is applicable to your child, I would say highlight it and then throw it all together when you do the petition. Because again, this is really the crux of it. If the court looks at the petition and says there's not enough information here, they are going to dismiss that petition and send it back to you and say, nope, not enough. And then you're back to square one, having to file again, including that hefty filing fee. The filing fees for these petitions vary a little bit from county to county, but it's usually somewhere between $550 and $700 to get the court to even pick up the petition and take a look at it. So you definitely want to get it right the first time. So do look through all those different scenarios and figure out what's applicable to your child and put together a really persuasive paragraph that demonstrates why your child is in need of a guardian. So now down at paragraph 4, this is where we're nominating. Okay, say we do presume, or we do convince the court that we are in need of a guardian. Who do we want it to be? So 4A, it's in the best interest of the proposed ward for the following individual to be appointed as guardian. Now that says individual. It can also be individuals. I get that question a lot. And it is fine for, usually it's parents, for parents to be co-guardians. With that, as long as the parents are both actively involved and equally involved in the child's life. Very important to realize that when you have co-guardians, it's not an either or situation. It's a both and situation. So 2 guardians means you have 2 halves of a whole. So it also means that doctors that you deal with, when you present letters testamentary and say, okay, here, I am my son's guardian, and it says Mr. and Mrs. Smith are the guardians, the doctor could say, okay, great, Mr. Smith, I'm glad you're here. Where's Mrs. Smith? Now, if you have long-standing relationships with doctors, or if the first time you go to a doctor's appointment, maybe 2 people go and you make it clear that, either of us can act, that is fine. And realistically speaking, a lot of times doctors will allow for that. But if you find yourself in an emergency situation, pulling up to the emergency room, letters of guardianship in hand, and only one of you is there, it could be a problem. I'm not saying it would be, and that even after I give this spiel to parents, typically they say, nope, we both want to be co-guardians. And I understand that, but I just have to give that little caveat, little warning. If there is a parent who is constantly traveling for work, then it might cause some complications there. The other question I get a lot of time is whether divorced parents can be co-guardians. And you can. I've done it a handful of times, but it really, really has to be the right situation. If the 2 parents just don't want to be married to each other anymore, but get along fine with regard to parenting their child and are on the same page and are equally involved, then it can work. I have seen it done, like I said, a handful of times in 20 years, but it absolutely can be done under the right circumstance. So that's where you would nominate someone to be a guardian. Likewise, you can nominate someone to be a conservator if you need one. If it turns out that you're bypassing the whole conservatorship process, then you would just put NA there for B, saying, don't need a conservator, thank you very much. Then we move on down to paragraph 5. The foreseeable duration of the proposed ward's incapacity is permanent. So you're going to put permanent into that blank there, which this also often leads parents to think of and leads me to think of, well, can this ever be undone? And a guardianship can be reversed. It's called a restoration. The powers of the ward can be restored. It is up to your child, or you as guardian can take part in that too, to file a petition with the court, several years down the road if things have changed, skills have progressed, awareness of, safety issues has, been worked on. then you can have your rights restored under a guardianship. You file a restoration petition, and then as long as it's the reverse, as long as your child can demonstrate that he or she is able to make significant responsible decisions with regard to his health and safety and or the management of his property, then yes, the guardianship can be restored, but it does require going back to court to make that happen. The courts love to do it. Likewise, I've been involved in less than a handful, two of those in all my years, but it's a great occasion when it does get to happen. But otherwise, it's going to be permanent, and it's going to remain in place until an order to the contrary is entered by the court. So we just put permanent in that blank, and then the court should allow the proposed ward to retain the following rights and powers. So it might be none. When you look at the guardianship and like everything we went over in the last meeting, as far as all the rights that are removed from a ward in a guardianship, the right to enter into contracts, the right to consent to medical treatment, the right to get married. There's a laundry list of rights that are removed, and you might say, yeah, that's exactly the rights that we do need removed because we need mom and or dad put firmly in control of making those decisions. So you might say, yep, we need to remove all the rights. However, there are some rights that might need to be retained. For instance, do you want your child to have the ability to get married? As you might recall from our last meeting, there can be some complications with that. Marriage can mess up public benefits. And a lot of just parents in general, I think, might like to have some say-so in who it is that their child marries. That's another discussion. But one of the rights that we see that most commonly these days that we are needing to address and are needing to have the ward retain the right to do is certain rights that are associated with attending a post-secondary education program. In particular, this came up, we had a client whose child was enrolling in the Destination Dogs program at UGA. And under that program, the person themselves, the student themselves, had to be able to select his or her own curriculum with guidance, had to be able to consent to having his photograph used in publicity for the program, and also had to be able to agree him or herself to the honor code. And so when Destination Dogs found out that this client was under a guardianship, they said, well, wait a second, he or she doesn't have the right to enter into a contract. So that's a problem, because that's what the honor code is, and that's what agreeing to have your photo used is. It's a contract. So we were actually able to go back to the probate court and get certain rights restored. Literally just those little rights. We went to the court, filed a petition, and the court granted it. So now going forward, if your child is going to potentially be a student in one of those post-secondary programs, I call out UGA just because it's the first one that we ever interacted with, not because I'm an Auburn Tiger. I bet Auburn has some of the same for their Eagles program. When we know that a post-secondary college program might be on the table, we do want to look into that and then find out from that educational institution, are there any rights that this student needs to retain? And if so, you can just put them in there, and the court will, knock on wood, in my experience, absolutely let the ward retain those rights, because they're thrilled that the ward's going to be participating in a program like that. Went too far there. So section 6, this one also often raises a lot of eyebrows and gets a lot of questions in filling out these petitions. So I'm just going to read you through here the requirements here, and you'll note that I have highlighted. The law requires notice to be given. So notice means a copy of this petition. So as I had mentioned earlier, not all guardians are doing the right thing. Someone might be up to no good. So the law sets forth a laundry list of people who need to get notified that this is happening. And essentially that's on behalf of your child. If you're up to no good and then you are required to notify some of these people and they go, wait a second, there's no way this person should be the guardian. That's kind of the rationale behind all this. So the law requires notice to be given to a spouse, if any. Typically, I think amongst the focus crowd, we don't have too many spouses. But if there were a spouse, that person is who must receive notice. Also, living children whose addresses are known. And again, you think spouse and children, that's weird. Well, don't forget, this guardianship process, yes, it's used in the capacity of young people with special needs reaching the age of majority, but it's also used if we've got 85-year-old mom who never did powers of attorney and now we need to sell her house or move her to an assisted living. So sometimes we're doing guardianships, for people who are much older and may have a spouse and may have living children. So those people are required to be notified. So again, we don't have any of those probably here in this crowd. But if there are no living adult children whose addresses are known, then at least 2 adults in the following order of priority. Lineal descendants of the proposed ward. So again, that's bringing in kids and grandkids. If there were grandkid is a lineal descendant. If there are none of those, then parents and siblings. And so that's where we typically fall. Here is we have, and a lot of times our 2 parents are serving as the co-petitioners. Okay, so we can't list them. It has to be someone other than the petitioners. As you see, I've got highlighted down there. Petitioners should not be counted. So at least 2 adults in the following order of priority for us is often going to mean parents and siblings. Now it has to be adult siblings who are over the age of 18, which if your child is the youngest of your bunch, then that works just fine. But sometimes we might not have any siblings who are of the age of 18 either, in which case finally we jump down to that final requirement, friends of the proposed ward. And friend can be aunts, uncles, grandparents, or an actual friend. And so you just need to provide 2. Ooh, why is this? Sorry, I just got to notice that my computer only has 7 minutes of life remaining. It's plugged in. All right, not quite sure what to do about that, but let me finish this paragraph and then we'll move on. Okay, so here's what we're going to list. So of the people that you are listing, you need to list notice recipient number 1 and notice recipient number 2. So we're going to provide names and addresses and the relationship to the proposed ward. So it might be an aunt, an uncle, a friend. So whatever the relationship, it's to the proposed ward, not to you. All right, I'm gonna have to see if I can find another plug here or something. I'm sorry. Let's see. We're gonna take a little tour of my office here. Oh, you know what? I bet that's what it was. Okay. Here, I think this part wasn't securely fastened. Sorry. Haha, got it. Okay. Sorry about that. Okay. So those are our notice recipients. They are going to be notified via certified mail of the filings and everything that's going on with the court. We're going to get into a couple pages back here. I'll show you where they also can acknowledge service, in which case you can skip you still need to list them here, but the court won't actually notify them via certified mail, and we'll look at that in just a minute. But the main thing I wanted to point out here in particular was the relationship to the proposed ward. It's the relationship to your child, not the relationship to you. Okay, now moving on to paragraph 7. At this point, we've just got kind of a lot of yes or no questions that we need to check the box and let the court know. So first is, has anyone ever been nominated under a power of attorney for healthcare to serve as an agent for the proposed ward? So Again, if your child is young and has never signed powers of attorney, chances are the answer is going to be no. The reason all these questions are here is, again, thinking about grandma down the road who may have a power of attorney in place. That's going to be the person who has the ultimate priority in getting named as agent under the power of attorney. Excuse me, agent by the court. If you were to look back at your power of attorney, when you signed it, you say, yes, I'm naming this person to make all the decisions for me. But if I ever need a guardian appointed, here's who I want it to be. And so the court has to honor that. So if there were any powers of attorney in place, then the court would have to be made aware of that. And so again, as you would see down there, the next highlighted section here, it says attach the document as an exhibit if there is one. I'm thinking in your case, there's probably not going to be one. So same thing goes here. Has anyone ever been nominated by the proposed ward or any other individual, such as a spouse, adult, child, or parent, to care for the proposed ward? So this would come into play. For instance, a lot of parents say, okay, great, I'm going to be the guardian now, but what happens after I'm gone? Who's going to be the guardian? And parents should always have someone nominated under their will or in another writing to take over as guardian. Once you get sworn in, you get to nominate your successor, saying, okay, if something happens to me, here's who I want to come into play. But that isn't mandatory on the court. It's not binding that the court honor that, but that person becomes kind of like a super creditor. Unless someone can demonstrate that the person that I want to be guardian for my child is unfit, that's who's going to get put into that position. So this is where the court is asking there, has anyone ever nominated someone else to serve? So again, you're in the early phases of things and just getting a guardianship in place. So I'm thinking the answer here is going to be no, but if so, you would attach a copy of any document like that was in place. And then the court also wants to know, because again, this is all with regard to health and safety decision making, has anyone ever, has an order related to CPR on the proposed ward or other life-sustaining procedures ever been entered? And I think in your case, that's going to be no. You would attach a copy of it. Just jumping all around here. Okay. So next, it starts asking about trusts, which if you have done estate planning for yourself, your child very well may have a trust, or if your child has ever gotten any litigation proceeds that have been placed into a trust, your child may already have a trust. So this is simply the court asking, hey, is there any sort of trust in place for this child? So if there's not, of course, you would just say no. But if there is, you can say yes. And you'll notice there it also says attach the document as an exhibit to this petition. So we want to answer the question first of all. So I'd say the most common scenario for me is that my clients have done their estate planning and they do have a third-party special needs trust that's there for their child. It has a little bit of money in it or doesn't have any money in it yet whatsoever because it's just part of their estate plan. So if that is the case, I like to put that in there and show the court, heck yeah, we've got a trust. We've done our homework, you know, gets a few gold stars on our file maybe. So it says, yes, the parents of the proposed ward have established an inter vivos third-party special needs trust for the proposed ward. Now, what I don't do is actually attach a copy of that document to the petition, and a couple reasons for that. One is the filing fee. Typically, a lot of these guardianship filing fees, you're charged $2 per page to record the petition. If you've got a 30-page trust that you need to record, then that's going to drive your filing fee up, you know, from $650 to $710. And I just don't want to do that. Secondly, this isn't, you know, a third-party special needs trust like this. The court's not really that interested in it. But again, we're going to do our part. We will disclose it. And if ever asked for a copy of the petition, absolutely. I mean, a copy of the trust, we will provide it. But I just don't provide it going in. But I do like to let the court know that, yes, parents have done their homework and we do have a special needs trust in place. Likewise, if you had a litigation trust that had already been funded, you would disclose that there as well. And still, I wouldn't provide a copy, wait till someone asks for it, which typically they don't, by the way. And so then, has any other document been created? The court is really just trying to do their due diligence here and say, is there anybody else in line that, you know, should be notified, should be put in place, that has been designated and part of the proposed ward's life and should be involved in this decision making. They just are really trying to ask the question 14 different ways to really cover their bases, and just to make sure that, again, because like I said, these proposed the petitioners, the proposed guardians and conservators aren't always with the best of intentions. So they just are really trying to look and see, you know, making sure no one's being skirted or left out of the loop here that needs to be included. So that's what all these questions are about. Does another person have authority to act on behalf of the proposed ward? No. Question 8, does anyone named above or the proposed guardian's conservator have a financial conflict of interest with the proposed ward? And so typically our answer is going to be no here, but if for some reason the petitioners do own real property or have a joint bank account with the proposed ward other than a rep payee account, you know, that could potentially be a conflict of interest. A joint bank account and even joint ownership of real property typically is not going to boot you out of the running and say, oh, can't be guardian, can't be conservator. The court just wants to be made aware of it to know to, you know, keep an eye on that going forward. So if you do have any joint ownership interests with your child, you would disclose those there at number 8. Number 9 has to do with emergency guardianship and petition. Let's say you weren't here today, you never got all this information, you never got a guardianship in place, but then something happened. And so now you really need the guardianship and you need it fast. You can't wait. You can't wait 3 months to get it in place. It can be very difficult to get those. The standard for getting those is you have to show an immediate risk of irreparable harm to the ward. So I would never bank on that and say, oh, we're just not going to do this right now. And, you know, if an emergency happens, we can always get that emergency thing. First of all, it's hard to meet the standard. Secondly, they're only good for 60 days. So getting an emergency guardianship, while it can be great in the moment, it's not going to be good for the long term. And you do have to file a regular petition thereafter. So you're looking at 2 of those giant filing fees and plus the hassle of going through all of this twice. But just in case there ever has been an emergency guardian or conservatorship, the court wants to make sure that it's aware of those proceedings because it might have been in another county. So that's why the court is asking these questions. Again, in your case, I think the answer on both of these is going to be no. But if it has, you would disclose all the information about the emergency guardianship and conservatorship. Now we move into the portion, so we're at paragraph 10 of the petition, and we're moving into information about the finances of the ward. Now, if you are only asking for guardianship and not conservatorship, I don't mess with all this and fill all this out. I just put NA, because guess what? Not applicable. We're not asking for control over the financial side of things because there really aren't any finances to speak of. We are asking for control of the health and safety side of things. So I just save the hassle for myself and my clients, and we leave this part blank with the exception of if there is Social Security income coming in, and a lot of times it's SSI for our young people who are just turning 18 or just have turned 18. So we will disclose the amount, the annual amount that is received from SSI. So in this case, I had it as my example, $9,000. And then I put a couple asterisks by that and make sure to point out to the court, yes, we have this income, but it's paid to the ward's mother as the representative payee. So again, we don't need any more oversight. We've got oversight over this judge. We don't need a conservatorship to be put in place for that. All this. Now, if you did have a conservatorship, then yes, you are going to need to fill out all of this fun stuff as far as the information regarding the finances of the ward. But overall, in this circumstance, we're going to be able to avoid that. And as you can see, what the court's interested in there is, okay, what's the ward's income? What's the ward's expenses? What does their financial picture look like month to month? And then down here at the very end, they would get you to summarize the income and expenses. And then as part of the conservatorship, you would say, okay, these are the monthly expenses. So court, can we please have your permission to spend this much each month? The court would issue a separate order that says, okay, conservator, you're authorized to spend, $842.78 each month for the ward. And as long as you stay within that budget, it's fine. But if something came up and you had to go above that budget, then you have to come back to the court and ask for permission to do that spending, which is again why I say it's a bit cumbersome. All right, paragraph 11. Guardian ad litem. So as we go through all this process, your child is going to have an attorney appointed for them. That is the attorney that represents them and advocates for them. And that is because your child is about to have some rights taken away and they deserve to be represented. So that court-appointed attorney is advocating for what your child wants. Now, even if your child were saying, I don't need a guardian, I'm fine, I can do all this on my own, it would be, if there's validity in that, then that's what your child's attorney is going to argue. If there is not validity in that, if it's just your child's opinion, but it's not reality, then the court-appointed attorney's job is going to be to say, Your Honor, my client feels that he does not need a guardian. But if the evidence shows otherwise at the conclusion of the hearing, then the court's going to make their ruling. So, I wouldn't be concerned that just because your child's going to be stubborn, that it's going to be a true obstacle to you getting guardianship, unless there's some validity to it. So that's court-appointed attorney, as opposed to a guardian ad litem, which is listed here in paragraph 11. So a guardian ad litem is another attorney that potentially could be brought into the mix here if you're asking for something kind of outside of the box. If you were asking for permission to take funds that were in your child's name and put it over into a special needs trust so that you could get benefits, for instance. That is something that's a little outside of the box, and the court says, all right, I'm going to bring in another attorney, not the one who's advocating for mom and dad, and not the one who's advocating for the child. I'm going to bring one in who's going to be an objective voice in all of this. So it's pretty unusual in a petition like the ones that I think that you'd be filing that we would have any need for a guardian ad litem. So NA is probably going to be your answer there. But just to give you an idea of where that might be involved if you were asking for something outside of the box. If later on down the road, you wanted to relocate your child out of Georgia to another state, you have to ask for court permission to do that. And that's an instance where a guardian ad litem might be appointed as well. So they're just, Georgia code sets forth some circumstances that the law considers unusual that they think needs an extra set of eyes on it. But I think for the time being, what you would be filing here, we're going to have NA for that. If your proposed ward has been physically present in another state for at least 6 consecutive months during the year preceding the filing of the petition, you have to disclose that to the court. This was brought into the Georgia code in response to what you might hear referred to as granny snatching, where one child, the child down in Florida had mom, and then the child from Georgia shows up, brings mom back to Georgia, and quick is trying to file for guardianship before sibling in Florida can do anything about it. So again, not applicable probably in your circumstance, but that's just to give you an idea of where the court was coming from on this. So I think in your case, this would be no. Now, if you have moved here from another state within the past 6 months, then you would say yes to this. And there are some additional questions that you have to answer about, the ward was out of state during the last 6 months. Okay, well then who were they living with? And you say, well, it was still with us. And the court's gonna go, oh, okay. Or if your child is at a program that is out of state, but yet Georgia is still their real residence, you would disclose that on here. And again, that's a logical explanation for things. This is really just looking, to see if anyone's up to no good in removing someone to Georgia just to seek guardianship. But you do need to answer those questions. All right, coming to the end here. Section 13. Go ahead and just copy this word for word when you're ready to file your petition. Again, this has to do with making sure that no one is venue shopping. Say, hey, gosh, Fulton County Probate Court is, really bogged down, and I heard that, Gwinnett is faster. So let's, go up and rent an apartment in Gwinnett and then file for guardianship. So this is all just to make sure that you're filing in the right court. So just literally copy. The proposed ward is domiciled in DeKalb County, and accordingly jurisdiction lies, that's supposed to be lies, not lives, lies with this court pursuant to, and there's the code section, the proposed ward has not been removed to this county solely for the purpose of filing this petition. Section 14, if there's any additional data that is lacking, then you can just put that information there. I would say probably the most common thing that I list there is because you notice back when we were talking about who had to be notified, their biological parents do have to be notified. If there is an absentee biological parent, that's probably the most common thing that I put in this section. Just saying, petitioner has lived with his father for the past 20 years. Mother is, only sends Christmas cards and, whatever it is, because parents do have some pretty strong rights in guardianship hearings potentially. And so if there's a reason they shouldn't, I want to make that clear. So that's probably the most common thing that I would ever put in section 14. Other than that, we leave it blank. So you can put NA there. Then our just conclusion statement. It's in the best interest of the proposed ward to have a guardian appointed. So then our two petitioners will sign at the end of the petition here and as well and provide their name, address, phone number, etc. You're doing this on your own. So you just put NA there for the attorney. You certainly don't have to have an attorney to get this petition done before the court. And we consider these workshops that we do through Focus as pro bono work, because we're really giving you this information so that you truly can do this on your own. So you just put NA there for the attorney. Now we have the verification. This is where you are swearing to have the truth in the petition ahead of time. So everything that was on the previous pages, now you're signing a verification. So it's going to be in Georgia. You list the county where you sign it. So even if you live in Fulton, if you work in DeKalb and that's where the notary is and that's where you signed it, that's the county that goes in there. And so then you would sign and print your name. Now you can either sign these in front of a notary, or if you're going to be going in person to the court to file the petition, then you can just sign in front of the clerk at the time that you file. Caveat on that, a lot of courts right now are not taking filings in person. They're only taking them via mail. So of course, if you do that, keep a copy of everything that you are going to file. Call them ahead of time and find out the filing fee so that you can send in that check and filing fee with them. But basically at this point in time, regardless of which court you're dealing with, call, get a clerk, ask to speak to someone regarding an adult guardianship and say, hey, I need to file this petition, and let them tell you all the particulars of what it is that you need to do. Because it might be that, if they're not taking them in person, then you do need to go ahead and find a notary and get it notarized before you file. Notarization right now, we're under an emergency order from the governor, and notarizations can be done via Zoom or FaceTime or any real-time video communication. But I don't know that the courts are allowed. I seriously doubt the courts are allowing that for initial petition filings. So then part of your petition as well that you should go ahead and send into the court when you file is the consent to serve, saying that, okay, yes, judge, if you find that I'm the appropriate person to serve, I agree to do that, which of course you do. You wouldn't be asking in the first place, but still, this is kind of your acceptance of the nomination to serve. And so again, you just kind of fill in those particulars and then sign. If you are going to have a conservator, the conservator would sign as well. Otherwise, you can just put NA. And this is the doctor's affidavit. So hopefully you are using 2 petitioners, and so you don't even need to complete or file this document, but it will be in there. So I just wanted to address that since I know that you will see it. Now, this is your acknowledgement of service. So this is what I was talking about, where we have our people who have to be notified of the court, notified of the filing of the petition. So if you just list those people there, the court will go ahead and send a copy of the petition to those people via certified mail. That's how they'll get served. Or in lieu of that, you can have them go ahead and acknowledge. So let's say you had Aunt Betty and Uncle Bob that were going to be, you know, serving as your people. You could get Aunt Betty and Aunt Bob to go ahead and sign ahead of time, have their signatures notarized. You put that with the paperwork when you send it into the court, and then that saves the time and effort of the court of having to notify those people. Typically, this is the route we would go. I like to get the acknowledgements ahead of time and do that. Right now, with it being difficult to get notaries in place, you know, it might not be that easy for Aunt Betty and Uncle Bob to go get their signatures notarized. So in that case, you could just go ahead, give them the information, and then just let them know, hey, something's going to be coming in the mail for you from the probate court. But that's all that you want to have done. Important thing here is make sure the notary stamps once for each signature. So if they go to the same notary, the notary needs to stamp twice, one for Aunt Betty, one for Uncle Bob, and also write in the date of his or her commission expiration. Write that in there, and hopefully they would do that because the line is there to remind them, but also the court definitely looks for that. So once all of this gets filed, you send all this to the court, and the next thing that will happen is you will get paperwork back from the court notifying you of your child's evaluation. Your child has to have a medical evaluation as part of all this. And that is because the court can't take your word for it. The court needs to hear it from their own independent medical examiner. So the next thing you'll get back is a notice of evaluation. Like I said, some courts are doing those virtually now, but you'll get notice of a date and time and place where you have to make your child available. A lot of times the evaluator comes to you, to your home, and conducts that evaluation. There will also be notice of a court-appointed attorney. That's the attorney who is going to represent your child. You might or might not hear anything from that person prior to the date of the hearing. You might just meet them at the hearing. And then once the evaluation takes place, as long as the evaluator comes back and agrees that there is a need for a guardian, then a hearing date will be set, and you'll get notice of that from the court as well, and then you will go to the court. So that's just to give you an idea. Once you get all this paperwork filed, what happens? And so notice I said you will get back from the court via mail. You'll get all that via mail. Your child will get served with all that via a process server or sheriff's deputy. So I know that we have room here for that you were able to submit questions. Let me see if I can get back. Okay. Can we start this process after the child is 18 years old? Yes, absolutely. You know, I get clients in a lot who will say, oh, well, my child is 30 and we've never really needed to do guardianship. We had the same doctor all these years, and but now we're going to this new day program, or we're moving into a residential situation and they're asking about guardianship and we've never done it. Absolutely, you can do it after the child is 18, whenever the need arises. So the earliest you can do it is 17 and a half, but absolutely you can do it after. Next question, do you have to put NA and all of the blanks that aren't filled in? I recommend it because it just shows to the court that you address this, you're aware of the question, you're not skipping it. It's not that you're not telling them something, it just makes it very clear. So I always recommend, yes, putting NA to anything that doesn't apply. Next question, in a situation with co-guardians and the ward is at the hospital / doctor, etc., with one guardian, can the other co-guardian be contacted by phone, or does co-guardian have to be physically present? I would have to believe that contacting someone via phone or FaceTime, something like that, especially in this day and age, would work just fine. And, you know, really, like I said, it doesn't mean that doctors are going to absolutely require that both of you be there all the time, but I just have to give that caveat because I don't want you coming back later saying, well, you never said, you know, this. So having co-guardians, like I said, can provide some challenges, but most families and couples that I deal with decide that they still want to go that route. For the SSI per year, 9,000, what do we put in the blank if the ward to be is 17 and will be 18, but doesn't have any SSI yet? I would still put, to the extent you know the amount, I would put that there. If you don't know the amount yet, I would just put, you know, TBD and put those same asterisks there saying, you know, yes, there will be SSI, but we will have a representative payee, just making the court see that, you know, you're aware of all these issues and that there's still not going to be a need for a conservator to manage that. Number 4, is it better to type on the PDF for this form or handwrite? Handwriting is absolutely fine. It does not have to be typed on there. If your handwriting looks like mine, you might want to type it. But apart from that, is, you know, nothing fancy about it. You can absolutely write on that PDF, and those PDFs are a pain in the neck, and I understand if you do just want to write on them, no problem. Well, thank you very much for your time and attention today. I hope that it's been helpful. I hope it's emboldened you to truly believe that you can do this yourself, because you absolutely can. And I will look forward to seeing you at our next event, or you seeing me, I guess I should say. Hopefully I'll see you too.